Good afternoon, everybody. It's a pleasure to welcome this final panel to the Digital Markets Forum. Let me just introduce them from my far right. From your far right, you have Daniel Friedlaender, Senior Vice President Europe for CCIA, Raymond de Rooij from the Authority for Consumers and Markets in the Netherlands, Audrey Scozzaro, Vice President Global Affairs at Qualcomm, Rees, Director of Global Public Policy at Epic Games, and Carel Maske, Senior Attorney at Microsoft. So welcome everybody to this panel. So you've heard about the various CERRE reports assessing the DMA process and compliance, future steps to be taken in terms of evaluation. What we'll do with the panel is I'll ask them a couple of questions to get them going, and then I'll take a few questions from the floor towards the end, provided there is time and interest. So the first question is asking you to look back to what has happened over the year in the DMA. You've all been involved in DMA processes in one way or another, and maybe you can give us your assessment of compliance and enforcement processes to date, what works, what doesn't work, what needs improvement. And I have a tentative running order, but as we've discussed, if you want to intervene when somebody has come in, feel free to stop me. So Leo, could you start us on this?
Sure. Can you hear me through this? Great. First of all, thanks to CERRE for hosting us. It's a pleasure to see so many familiar faces in here as well. I feel like we've all sort of been on a journey the past year, and it's nice that we get to meet up equally regularly now than in 2024. I'm going to take the same approach that I think Aurélien took on the last panel, which is to speak a little bit more in practice than in theory, because I think there's a lot of good theory in what CERRE has produced, but I think, you know, a year in, we have the benefit of being able to speak a little bit specifically about what has happened. So briefly about Epic, I mean, we're a US company. We're based in North Carolina. We view ourselves as a beneficiary of the DMA, which is not something you hear all the time from American businesses nowadays, but it's a law that we think is opening up significant opportunity for us. We, in August of this year, launched the Epic Games Store on iOS and Android. That's one of the first major alternative app stores on iOS. And at the moment, Europe is the only market which we can operate in thanks to the DMA. So I think, you know, it is no exaggeration to say that the world is watching the DMA even now, 1 year on. We've operated a store on PC for some time. We started in 2018, and our way into market was to offer much more favorable terms than the incumbent, which is Steam and a couple of other platforms. And what we've done is taken a very similar approach here. Our terms on iOS and Android are rather simple. We charge developers 12% if they opt to use our payment system, and 0% if they want to use their own. That comes from a deep-held belief that the developers bring value to the platform and not the other way around. And for those of you who don't follow this super closely, that's in contrast to the 30% that Apple charges for transactions through its App Store and Google charges through its Play Store. So we think that on its own, on basic market economics, should have led to more consumer choice and greater competitive pressure on these platforms. But I think, spoiler alert, it hasn't. We've seen significant issues, and I think I'll come to your question in talking through some of these now, Giorgio. So I've sort of bracketed these as the 4 Fs. F number 1 is fees. We've seen significant disincentives for developers to take up the opportunity to use alternative distribution because Apple and Google have often simply made them uneconomical. In Apple's case, it's created entirely new terms and introduced a new per-install fee, which effectively makes it the gatekeeper to the DMA, rather than them being subject to the DMA. We've seen the second F, friction. To download our store on iOS, you currently have to go through 15 steps from clicking download the store to getting it into the palm of your hand. That's compared with it coming pre-installed on your phone if you want to get to the App Store. On Android, it's 12. The data that we have found shows that over half of consumers never make it to the end of that journey. So that's an obvious disincentive both for consumers who give up and for developers who know that no one's going to get to their content. The third F is fake security. Now there are, as pointed out by the Apple panelist earlier, there are legitimate security and privacy concerns with opening up platforms to competition. But there are also completely sham ones. So to give you an example, when we notarized our, which is the process that Apple makes all apps go through to get onto the iPhone, when we notarized the Epic Games Store in August, we received a rejection saying that the button that you click to download apps from our store, which we'd written get under, was too similar to the get button that they have on their app store. Now, I don't know whether Apple owns the rights to use the word get or not. I'll leave that to the kind of IP lawyers who might be in another room in this building. But the point is that that is not a security reason. And we've seen all kinds of protectural steps taken by these companies along the way. The final F is perhaps the most important, and it's the reason why I'm speaking on this stage and not any number of companies that could be here right now, and that's the fear of retaliation. The day before the DMA came into effect, or sorry, the few days before, Apple unilaterally terminated our developer account. And in response, the Commission mercifully acted incredibly quickly to say to Apple that this was unacceptable. The reason that Apple was cited, by the way, was a legal letter addressed to our CEO saying that his criticism of Apple's DMA compliance plan suggested that we weren't going to take it seriously. So I think if Apple is able to, and these platforms are able to take these steps without fear or without knowledge that the Commission will respond, we are unfortunately in a situation where this law simply is not going to work. So that is an example where the Commission was able to step in and improve the situation, but there are probably lots of other situations where something like that does not happen. So to kind of get to your question, I think the bottom line is we have a store that's a good, that is in operation. We are making strides, and the Commission is helping us, doing as much as it can to help us succeed and to help other alternative app stores succeed. But significant problems remain. And for me, I think it is very important that we're here today talking about the different forums we can create for companies that don't have the same privileged position that we do to litigate and to complain against these issues in order so that they can participate. But most important of all is that enforcement happens, because market confidence is not built unless people know that the law is going to be enforced against. There is a reason that not one of the top 100 games developers by revenue are on our store today. And that is because they do not have the business confidence they need to transact with us when they know that our ability to operate could be taken away at any time. So I think for me, it's all about strong enforcement, and we can kind of tinker with the engagement methods along the way, but that's the key that I want to say today.
Okay. Thank you very much, Leo. I have Daniel next on my list.
Thank you, and thank you for having me. Although every time you invite me, it's always at the very end of the day. And with a lot of homework to read. So I work for CCIA, and we're a trade association, a global one. I run the office in Brussels, so I work on quite a range of issues. And we represent both some of the gatekeepers and some access seekers as well. And so I'm not here to talk about one company or another. I do have 4 kids who play Epic Games, and I do have some complaints about your store, but that's maybe for another time as a parent. But I want to talk a little bit about process and a little bit about the wider moment in which we're in, linked to better regulation, linked obviously to the geopolitical moment that we're in, because I think it matters as we look back and it matters as we look forward. Before I get into what I wanted to say, I actually do think that in many ways, when we went through the DMA process, we all talked about how this was so novel, this was so new, there would be mistakes, there would be problems, there would be the need to review, as we're doing, and improve, but that the improvements could go in both ways too, that it would not only ever be sort of adding on new things. And as we heard from the French Autorité de la Concurrence, there's already, even before we do a review, this very public urge to add new things, add new powers, create less perhaps certainty for some businesses. And I can tell you that is something perhaps a little bit difficult. And the other thing I just flag in general is this wider sovereignty discussion that we're having. So let's assume that you're a company, you're operating in Europe, you are following European rules and laws, as I think we all want every company operating to do. The point is that you are operating as dependable partners. Now, obviously, there are disagreements between companies. There are many disagreements between my members, but the principle is there. And so my general worry, which I think matters also for this moment, is that you then say, but sovereignty, even if you're following all our rules, maybe because of where you're from, we still don't want you. And I think that's something we need to acknowledge, because a lot of the discussions and even the speech before seem to imply that. And that is a danger as we review, because it can cloud the review. So more specifically, I do think that looking back, we have had different treatment of both different access seekers and different gatekeepers that has created significant problems with trust in the DMA, with trust in the enforcers. We have seen very public interference of the technical process through political intervention, which has also, I think, damaged quite a few of the interactions when, because we talk to both gatekeepers and access seekers, and because we're a trade, we have to focus very heavily on process. And so I think that's damaging. And then when you hear that both the Commission and the national regulators are understaffed, and then you have political intervention, this is a cause for concern. We do agree with, I think, actually quite a bit of what Alex said in the intro, so I'm not going to go over that. And I think the report has a lot of very sound points on the overlap, on the contradictions, on the uncertainty, which we think in the past year have actually increased substantially because of the DMA. I would flag again very strongly that contestability does not mean, as now some people have said publicly, tracking very specific changes to market share, and consumer behavior, because that is I think, a dangerous road to go down, because we have seen some try to pick favorites in this process. And then that's also why a lot of access seeker communities have been very critical publicly about this, in a very different way to you, critical, Leo. I think if we're looking at also what was raised in the previous panel, some of the intrusive data disclosure ideas, I think will actually make things very difficult. Because one of the key things is that also access seekers aren't enforcement agencies. And so I agree with the review process to open it up in a very different way, but I also think we need to acknowledge that some access seekers have focused a huge amount of energy on changing the process and turning it into a business opportunity. And I think that has also undermined the trust at this moment. And then when we talk about simplification, and we have a huge list of all the questions that the DMA has thrown out, that no one has been able to answer, we have a problem. I want to echo again the issue on ensuring that any look back takes into account the fact that the people who've been doing this do not have the expertise in a lot of the sectors that they are changing and impacting. We've talked a lot about security and privacy. Were the people from the Data Protection Board there? Was ENISA there? No. Should they be involved in reviewing? Yes. So, I mean, I have way too many points to go through for now. I'm going to stop there. I think it's going to be far more interesting when we discuss and debate. And I also want to apologize. I do have a hard stop right after 5 to go pick up the kids from school, so I'm sorry.
Well, thank you for that. I mean, it's interesting you mentioned the DMA as being a business opportunity, as a negative, because that is precisely the design of the DMA, to open up opportunities for others. So maybe we can just come back to you and explain more clearly what you meant by that.
When you look at the process, so it started obviously with those very public hearings, which I think were unprecedented, where you had competitors being able to grill each other very publicly. And then a lot of the choices that followed, where frankly the Commission in very short timelines sometimes tried to fundamentally change business models, insert themselves into almost the coding process. Often it was done for, let's call them noble reasons, but often it was done with a very clear goal in mind, linked to a specific, unproven, at least to us, concern on how the business was run, which then led to picking favorites in terms of you have to choose one access seeker or the other, one sector or one part of the sector or the other to favor in your implementation, and this is how it has to be, and this is the impact that we want to see. And I think that is a negative outcome, which has hurt certain parts of European sectors. And I think that's something that we really do need to acknowledge as we move forward.
All right, okay, thanks. I have Audrey next.
Thank you. Can you hear me well? Yeah. So difficult to go after you, I would say. No, but first I would like to congratulate CERRE for this very important work. And I would say piece of work. This is the second year, so this is the second forum that with Qualcomm we've been lucky to participate. And we really need you as well to help us to better understand what is happening, because this is an important piece of legislation, which is only 1 year old, only one. So as a mom of a 9-year-old, there is a big difference when you're 1 and when you're 9, so I just wanted to share that. There are a lot of ambition as well with this piece, and a lot of expectation as well. So just to go back on the philosophy or, the genesis. Before the hearing, we had a lot before, before many, many years, a lot of discussion, a lot of report from the academia, a lot of consultation. But just to go back on why we are here today, the intent of a pro-innovative and pro-consumer and pro-contestability piece, I think it's still, the objective of this text, and we need a little bit of more time. I'm not going to say 9 years, but probably a little bit of more time to see how things are shaping. And as well, there are multiple challenges, multiple actors in this field. There might be new actors as well in the field, so I would say we need to be a little bit patient to see what is happening. I understand that, maybe being too patient is not good enough, but I wanted to share some additional views regarding the report. I'm not going to comment on what was said, but this kind of evaluation theme that you've been developing with Alexandre and you is very important. And as well, I think there is this idea of a kind of I'm not going to say an expert group, it was not an expert group, an independent expert that's at the end of the report, because we had to do, as you said, a lot of reading for the panel. But I think that could be as well a very good way to look at things that probably, for many reasons, policymakers or business community or consumer organization didn't look at. But I believe that there are ways as well to really look differently about this kind of new regime that is the rule in Europe. As well, I think this is important because it has to be right in the way that many, many other countries across the world are looking into what is happening here. I'm regularly looking at, more countries looking at the field, and a few months ago, less than 3, I was preparing a briefing, and I think I had, except I would say Europe, the UK, and the US, okay, but more than 10 countries as well, one way or another, looking at variation of the DMA or the DSA. And I've seen a report last week with now more than 22 countries. So just to say as well that whatever is happening here, even if it's year 1, other countries are looking at, what is happening and what could be the benefits or the challenges as well that, they could avoid. So I just wanted to share that with the group and happy to continue the discussion.
Okay, thank you. I think it's interesting you mentioned that maybe the spotlight on the DMA is also from other jurisdictions looking at how it's emerging. Let me move to Carel next.
Yeah, thank you very much. Thank you for having us. After hearing what doesn't work with the DMA and where there is room for improvement, and learning from Audrey, it's maybe a little bit early to say. Audrey would side with you. The baby is 1 year old. You might not know whether it's becoming a great football player or a lawyer. So let's see how this is playing out. But at the same time, I appreciate CERRE starting this discussion, because we need to think about these issues. What are we trying to achieve? Are we getting there? Just one observation from being very involved for Microsoft in the compliance with the DMA, it's not only a lot of work, but what we are seeing is a lot of professionalism, a big team, which we hadn't thought we would see, a lot of good work trying to make it work. And I think that's a moment to pause, because we are talking about regulatory process and how to improve it. I think when we started this journey with the DMA, there was no regulatory dialogue. I think today it's very much happening, and while there is a lot of value in thinking about how to improve it, I think it's important to recognize that a lot of the discussion is going, there is compliance, there is room for improvement, I don't negate that, but I think it's important to step back where we came from and where we are today, and I think it's a big success that we are here talking about a lot of enforcement, a lot of compliance, and of some issues to improve. So thanks for organizing this discussion, and I think I leave it at that.
All right, okay, thanks. And then I have Raymond last, and perhaps one point you could discuss with us is, we've seen a call for more enforcement, and then we've seen now with Carel a reflection that this dialogue approach is an alternative way to secure effective market outcomes. So in a way, the regulator has a choice between different instruments, and to pick the right instrument is sometimes a challenge. So maybe you could discuss a little bit how an agency goes about picking.
Yeah, thank you. I will get into that. First, I'd like to extend my thanks as well to CERRE. I think this whole process is very useful, including the papers you wrote, also as input for the evaluation, which is upcoming. Still, it's early days. So if one of the questions was looking back at last year, what do you think went well, and what would maybe could be improved? And I'll get to your point then later. Well, actually, I want to also put a positive note here. We think, as ACM, as a regulator, that the past year has been very encouraging. We really think the Commission did great work. Both in the regulatory dialogue, but also in the first non-compliance cases coming in, but the recent specification decisions. So there's a lot of effort going on with limited staff. So yeah, I think it's really impressive if you also look at these decisions and how detailed they are. Can things still be improved? Yes, of course. But of course, if you look at the proof of the pudding in the end is in the eating. So do we see outcome already? Do we see more innovation, things like that? It's too early days. We still don't know if the football player will be in the major league or in the bottom league. We don't know yet. But yeah, that's also, we come to that later, I think, why it's important for the evaluation really look at which indicators do we look at for this past period. But that's, I think, the second half of this this discussion. Another thing we would like to mention, which we thought we have positive experience with, is the cooperation with the Commission, with, let's say, the joint teams. We invested a lot in it. I also heard some of the talks. Yeah, it's a bit of struggle also for the national authorities, because, well, it's maybe no secret, budget cuts are, well, commonplace nowadays in the different countries. So we're actually also now facing budget cuts, but still, yeah, we can, because we have DMA and competition in one department. I mean, we can prioritize between the two, so we really look at, okay, what is the problem, and yeah, can we then more focus on DMA rather than maybe an Article 102 case? Nevertheless, it remains difficult, but yeah, we have invested in also seconding people at the joint teams in Brussels. I think 6 in the last 2 years, 1.5 years. So that's rather a lot. But we also see that helps in, that's the next stage, in working more, not only as delivering, let's say, hands and brains in the team of the Commission, but the next level will be really a joint project. Let's put it like that. But we needed, for that to happen, we needed the knowledge and the skills. So that has been the investment. So we were really positive on that. The only thing which maybe for the future still a thing to think about in that respect is, it was said that the Commission has a sole enforcer. That is true, but I think the national authorities are not relegated to just, how do you say it, informing and being a first point of contact, because we also have investigative powers. So we can do a lot up till only the final part we can't do. So, but we can ask questions, we can visit, we can do dawn raids, things like that. But the thing here is then, how does that fit to the regulatory dialogue? So I think that requires a lot more thinking, and how do we coordinate with the Commission that we are aware that if there's a dialogue going on the same topic, we don't start, or we are aware that if we use our investigative powers or not. So that is on that. What could improve? Well, that has been said a lot, so I won't delve too deeply into that. But the involvement of civil society and business users, I think we could look at what worked well, what didn't work well, and how can we further improve that, and can it be more embedded in the process. So that could be one of the process indicators to look at. And then your question on whether or not what would be preferred, or when do you use a dialogue or more be more persuasive, let's put it like that. Well, I think that depends. It is maybe a simple answer, but I see it as a kind of an escalation ladder. So I mean, if company gatekeeper shows that it's willing to really seriously look at the requirements and shows good progress in that, you keep in a dialogue. But if there comes a point, and that is of course, when is that point that you say, we now feel that you're dragging your feet, or it should be clear already, we have had a specification decision, you name it, and you should just now comply. And that is case by case. You can't say, So you have to think about it, and like I mentioned, you also have to think about how that aligns with the national authorities. So that's what I would like to say.
All right. Okay. Thanks. Maybe I go back to Leo's original remark, because you said you want a lot of enforcement, and you've identified a lot of sort of regulatory hurdles along the way. I mean, are all of them necessarily solved by better enforcement, or are there other ways? For example, the point about identifying whether a particular security feature is risky or not. I mean, is that maybe better resolved in alternative fora than litigation, or do you think enforcement is the way to go to solve all the 5 Fs?
Well, I think I'd echo the comment there that it sort of depends, right? I think what I'm referring to are specific contexts in which there has been blatant non-compliance. I mean, the Apple panelist earlier remarked that some of these laws blatantly aren't self-executing. I mean, I think they are. The ability to steer is something that has been around on lots of different platforms for a very long time, and there are lots of models they could have borrowed from in order to find a solution for that. I mean, these companies are the best at user design in the entire world. They've literally built their businesses around that. So I think what I'm talking about is instances where the DMA is very clear, and where there is actually, for that particular instance, fantastic precedent in the Commission's investigation into how Apple has dealt with steering in the context of music services. So I think there's a clear non-compliance finding. Obviously, across the piece, there are areas of greater nuance which might require different approaches. I think in the context of, for example, security in opening up the ability for alternative app stores to operate, we think that that's something that opening the market to third parties, or indeed allowing an objective independent arbitrator to set the baseline there, is something that probably competition could lead to better outcomes than where we are, and we'd have a bit more sort of objective truth in that space. So I think there are different horses for different courses, is what I'm saying. But I think that the areas of blatant non-compliance are the ones where I think really strong enforcement is now required to ensure that the market sentiment matches the ambition of what is a law that should unlock innovation in Europe.
All right, thanks very much. Anybody want to come back to any points that have been made? If not, we can move. Oh, John, please.
Yeah, just on that. I mean, I agree. It depends, but a lot of things seem obvious to some, and then you get a different perspective and look deeper at the technology. So in a lot of instances, there is a challenge that there are different ways of how you implement a solution. And I think where the challenge then is how to balance that. And the Commission plays an important role in trying to coordinate that, trying to get the different input. And I found that, type of dialogue very helpful in finding a solution that is balancing the different interests. Is first of all hearing and listening and understanding the different perspectives of these issues, which is huge as a task because the technology is complex, understanding the consequences of changing something, the business models are complex, the practices companies engage in are difficult to understand, and they're coming from very different starting points. So bringing all that together is one thing. Then the next thing is trying to achieve alignment across the different gatekeepers so that you have actually an enforcement that is across the board, disregarding, from, who is the gatekeeper at stake, but really thinking about how a certain obligation should be implemented to provide more transparency and guidance for future cases. So there is, a significant need to have these conversations, and those shouldn't be underestimated.
Okay, thank you. I don't see any other reactions, so let me move on now. We wanted to ask you to look to the future. And perhaps before I give you guys the word, today is a day where there's another conference somewhere in Brussels where they're looking at a study carried out on behalf of the Commission on the effectiveness of Article 102 remedies. A long study was published recently which evaluated very long-term, long way back cases and remedies and how these remedies had impacted the market. And I think this is really excellent work that the Commission has tried to do, because an agency is only effective if it is willing to ask itself, have I done a good job? Have I provided the right remedies? And of course, these studies are also extraordinarily complex. So the easy criticism that has been made of this study of the Commission is too small a sample. But to even sample cases and to go through the market of impacts and to try to understand, as Alex was saying before, the causal link between the remedy and the effect is demanding. So I think, the fact that the DMA is to be reviewed very quickly, maybe too quickly, because at 2-year-old we may still not yet know the direction of the child. But on the other hand, the spirit of wanting to look for whether there is an effective impact is, I think, an important one for a regulator to self-understand where it needs to correct its approach. So with that in mind, I'd like to ask the panelists to tell us what they think are the most important aspects of the DMA that they think need to be reviewed, and if you want to talk about what sort of information is important to carry out that review, and then perhaps you can tell us. I'm going to start with Daniel, since you're time constrained.
Okay. That's very kind. Yeah, thank you. And just to be clear, I think everyone in this room wants the DMA to work and be successful. And I have acknowledged before just how much work everyone has put in, including the Commission. I also agree with the fact that it's very hard to review so much and something so novel so quickly. I even have an 8-month-old, and I can tell you that's even worse. But I would look at a few areas, and I actually don't agree that everything is so obviously self-executable. So perhaps we actually need to look into that and what is not, because there are massive and very divergent points of view on that, and I think that that's something we should look at. I would look also at the DMA just as an actual regulation in terms of, what is it effective at in terms of efficiency, right? So let's actually look at the costs, because the costs of compliance have been huge, whether it's for the gatekeepers, and some of them have published some pretty impressive numbers, but also the costs of compliance for business users has been have been huge. The costs in efficiency of consumer behavior, I think, and consumer experience have been big. I mean, Alex's point on the Google Maps is a good one. I have many complaints that I have then shared with actually member companies based on my user experience as a person with changes imposed. So I think that does matter, and often we have seen a lot of business users in limbo, so there's a cost to that, and I think that we should look at, because that we can look at now, because we already have a lot of information examples. I do think we should look at any legal uncertainty created, because that, again, we can look at now, and I think that matters. I think that we should also look at relevance. Is it actually serving European businesses? So I made a few examples on a few sectors that have been impacted. We're actually working on our own study looking at that to see positive and negative impacts. I would hope that the Commission doesn't only focus on positive ones, because there are negative ones, and to improve it, we need to acknowledge that. To Alex's point really on coherence and added value, I think it's important, because there are preferential choices being created. I think, again, on the wider context point as we're reviewing, we also have to review whether this fits in with the wider Commission agenda on simplification, better regulation, all of those important things for competitiveness, because you have on the one hand the Commission now looking to regulate gatekeeper behavior very carefully, but in other sectors you have related parts of the Commission who are talking semi-openly about trying to create new gatekeepers. And there's a coherence, trust, and credibility point if you're trying to then now create new telecom gatekeepers, which frankly parts of the Commission may be doing in the next few months. So there's a wider credibility point. Can you have an effective and credible DMA with business trust when you're perhaps doing the exact opposite in other sectors? There's also, frankly, the same question to be asked on some harmful gatekeeping on OEMs with standard essential patents. I know that's another discussion, but we need coherence from our institutions. It's just a wider question on Commission behavior. I'm certainly not attacking you specifically. This is a Commission credibility and work stream point, although yes, I could acknowledge that it would put a smile on your face. I do think that there's a wider sort of cost-benefit analysis that we have to look at, and I hope that the Commission will do that, and there are a lot of companies that would want to help. And again, I make the whole sovereignty point, because if the review goes into sort of sovereignty territory where even if you comply, we may not like you because of where you're from, I'm deeply worried about the geopolitical moment, as we all are, and we want decisions that are made now to be positive for the future, because I think business can come together and do good together and do good with consumers and for consumers, even if governments are in a difficult spot. So that's sort of my optimistic, hopeful point, to work with other businesses, users, and the Commission to make this a success.
Okay, thank you. Although I'm not so sure that any Commission official has used the sovereignty card quite in the way you've said it. I mean, I think the reaction has been to pursue a rule-based approach to whatever rule is being enforced.
It's the wider discussions on sovereignty that haven't quite touched, well, actually, no. From the Parliament, they have very much hit on DMA. And given, the Autorité de la Concurrence and the previous speakers were talking about whether the Parliament should have a more active role in reviewing compliance. That, to me, would be a very political step that would likely go down that road and could be very damaging to the credibility. So again, to Alex's point, going through the report and going through the recommendations, which are usually, I think, we'd agree with most of them. It's about actually checking what we can look at, and I think we can all agree on that, and avoiding areas where either the whole Verschlimmbesserung, for those who speak German, whereby trying to open up or expand quickly without knowing what you're doing, you make everything worse.
Right. Thank you. Okay, let me move then slowly towards me. So can I have Raymond next, please, on looking forward?
Yeah, thank you. As I said earlier, most of you said the same. It's early days, so the indicators we would focus on in evaluating is first the process indicators and output indicators, but not necessarily now focus a lot on outcome, because one of the outcome aspects, for instance, is increased innovation, which I don't think, how can you sensibly measure that within a year? And then another aspect is maybe also a little bit, it sounds maybe contradictory, maybe a little bit also of a forward-looking element. What I mean with that is how future-proof is the DMA in the sense that it should be presumably technology neutral, but how can it, for instance, handle things like AI? Or not, or other maybe new technological developments, and how do we view that? And if, I mean, you want to be flexible enough, I think, not to change the law all the time if there's some new important technology. So that is one aspect. Going back to the process indicators, yeah, you could, for instance, look, well, taking one step back, we have had a lot of results, but one of the reasons why the DMA was introduced, or one of the selling points, was also, I think, speed. So, because it was said, yeah, it's self-fixing, or how do you call it? And in that sense, takes a lot of less time now, for instance, a 102 case, which can take maybe 10 years, all the way to the highest court. But I think that is a thing maybe that has been missing in the discussion. I would applaud to also take that into account. What do we see as a reasonable timeline from non-compliance to compliance? Let's put it like that. And can we put some measures on that as well in the process indicators? That was something I would like to add.
All right, yeah, Audrey, please.
I will be very brief because he has to leave, so he has to wait 20 seconds to hear what I'm going to say, and then he's leaving. Daniel, you can, but you stay. No. I'm just saying that happy to have a discussion with you and your member and talking about standard essential patent, because it's really not the topic here. But if you want to talk about interoperability, access, level playing field, let's talk about standard essential patent, and you will see that it might give a good idea to your member in implementation of the DMA. Now, going back on the discussion, just to say it, you can go. Thank you. No, but thank you, Daniel. Just in terms, because we had a lot of homework, so I'm changing a little bit, the request, Giorgio, but I think what would be of interest, maybe for the future and for the audience and the member of CERRE, it would be to look at maybe next year or in 2 years of what has changed. And that could be a combination of things, with the indicator that you mentioned. Leo was mentioning the opportunity with the challenges of, having the Epic Store available. So that's one example, but there are others. I recall as well that there are new, and Aurélien can mention it, with the challenges too, but there are much more broader, accessible now to users. Maybe there will be more, maybe there will be less next year, we don't know. But that's, I think, looking at what is happening, depending on the articles and the opportunities. Just another example, not just about enforcement too, but if we look at Article 7 as well that Chiara was mentioning, there are some interesting development. I don't know all of them because I just look at some example, but there is, for the very geeky telecom people, okay, I know there is one in the room, maybe there are others, but there will be the new protocol of RCS that will be available very soon. It's here already available on beta, but this is the end of discrimination of users. You might feel it's something mini, but I think it took a lot of time for the industry as well for this to make it happen and accessible to users. There might be other examples that I'm not aware, but I think that if Giorgio and Alexandre and the team, you would be open, to this kind of example with good or bad, but that would be good as well because all of us, at least from, I can talk for regulator maybe as well, or the private sector or third party, we look at this piece of regulation from our own view, and there might be many, many things that we don't see, and we could see value in having the academic sector looking at it. So just wanted to share that. And any question on solar essential patent, I'm probably the most expert now in this room, but happy to answer any question. Thank you.
Thank you. Leo?
I'll try to keep it quite short. I think you'll sort of notice in the way that I'm talking on this panel is I'm trying to talk very specifically, and I'll take advantage of Daniel's departure to point out that there were few and far between specifics in what some of the stuff he was saying. And I think the reason why specifics is so important is because these are the products and services that we are using as Europeans, and that is the level at which the DMA needs to consider whether contestability is being created or not. And when it comes to evaluation, I therefore think that a lot has been said today about the information asymmetry that exists between the platforms and the regulator and the business users. And I think a really good starting point would be to look at areas specifically where it would be possible to produce data that is deeply practical, that then can be tested by other parties who are also experiencing the challenges and opportunities presented by that data. One example, specific, Google's friction screens in downloading on Android alternative stores, we have found that there is a really high drop-off along the way there. It would be great if Google was able to produce its own data that says what it sees that drop-off to be, and then maybe we could work with organizations such as Vanessa's to try and figure out what is happening there, so that we can figure out how DMA rights can actually be availed for European consumers, so we have the chance for outcomes that are going to create competition. So that's my suggestion.
Thanks very much. Very helpful. Carel?
Yeah, and just coming back to the report and the evaluation, Alexandre mentioned at the beginning, efficiency is one of the key areas for an evaluation and assessment. And I think while we don't know really the outcome in terms of contestability and fairness and what it does to innovation or European competitiveness or other more factors that are more difficult to assess. I think on the efficiency side, one important point is to think about prioritization in terms of the resources that are limited, the amount of work that is going into it, and aligning these priorities with the objectives of the DMA. I think that's where actually the credibility of the DMA is at stake. As a rule that is having a certain objective and trying to achieve not just red tape for companies and not just, a forum for discussion, but real outcomes. And I leave that there.
All right, okay. Well, thank you all very much for your suggestions. We do have a few more minutes. No, we don't. Okay, all right. My clock here tells me 2, but the person who's really in charge tells me no. So it reminds me to thank the panelists for this discussion. Thank you.